go on and on and on. That's the beauty of the system.
Well, the argument you're making now one that would fall within the business judgment rule? Could you advance that, putting aside all constitutional principles?
Absolutely not.
Why not?
The business judgment rule, I think, is a paper tiger. It goes to arbitrariness, capriciousness. It's not going to cover these kinds of issues. The business judgment rule, it's applicable, although I think it should be strengthened, very frankly, to reasonableness rather than arbitrary and capriciousness. May be applicable when you're dealing with financial issues of financial issues. I mean, people, we haven't really talked about the issue of waiver yet and whether or not people are waiving their constitutional rights, as defendants claim, when they purchase one of these properties. And our position is, of course, there is absolutely no free choice here. But the business judgment rule may be okay if you're dealing with the fiscal activities of the board, because when people do buy these homes, the one thing they do know is they are buying something that has some economic consequences, that they do have to pay the maintenance fees, and that there is a board that's going to set a budget, and they're going to set the assessment as to who has to pay how much to run this budget. So the business judgment rule may have some application in that situation, but not when we're dealing with fundamental rights.
Does that sum it up? Okay. Anything else?
Unless you want to talk about the issue of waiver, and I think this court's jurisprudence is so clear about waiver of fundamental rights in public policy, and the fact that this is no equal bargain. I mean, it always says
not of housing around. You're claiming that this is a contract of adhesion.
Absolutely.
That the people in Twin Rivers couldn't go anywhere else and buy property or afford property where they could have all the signs they want on their front property.
It is more and more becoming impossible. What we are creating is bubbles of no free speech zones, and in fact, those bubbles are coming next to each other, so that just one big bubble in places like East Windsor and West Windsor.
Let's go back to signs. Any common law basis or contractual basis for your achieving the results you seek in connection with the signs?
No, I think that's a constitutional issue, Your Honor. I think it's free speech. And again, this is a case under, Article 1, Paragraph 6 and 18 of the New Jersey Constitution, which applies, as this court has constantly said, not just to governmental entities, but as to other entities which exercise dominion over the people on what they call their property. And as I started on the waiver issue, always I found it humorous. If you sat down to buy one of these properties and said, by the way, I hear that I can't put a political sign on my property. I really like the right to put a political sign on my property. They'd laugh you off the table.
Most people aren't moving into communities to put up political signs on their property. But if a person has that type of concern that they don't want there to be any impairment on that right, you don't think there's plenty of property in this state where they could build a home, purchase a home, rent an apartment?
Not affordable, Your Honor. I mean, our multiple dwelling, data, I think is very, if you want to live in the East Windsor Heightstown area, it's almost impossible to buy a freestanding house for under $300,000. If you want to live in an association, the prices start at like $100,000. But the freestanding homes outside of associations are just not available. And this is not by accident.
Professor Askin, I'm sorry.
This is a consequence of state policy, which has required developers to create these associations.
Professor Askin,
I'm sorry, Justice Breyer.
Can you tell me where in the record there is any factual support for what you just argued?
Of course. It's the Lister affidavit. It's almost 100 pages long.
You can submit it after the argument.
Yeah, the Lister affidavit. It's the Lister affidavit.
If I could, I'll find it then.
Yes.
Is that in the record?
It's in the record. Lister affidavit is in the record. It's also the multiple listing of properties available on a given day. In conclusion,
I'm sorry. I just want to make sure that you and I are talking about the same thing. You have just argued that the reason this is necessary
The reason the constitutional rights must expand to cover these circumstances is because people have no other place to go. And I want to know where in the record that factual representation lies. Now, you've told me that that lies in the Lister affidavit. I'll look for it there.
Okay. And
Anywhere else?
I'm sorry, Rob. It also lies in the fact of the State Planned Unit Development Act, which is in the record, which is Chapter 61, Laws of 1967, which allow municipalities to create these associations with special zoning rules. And in East Windsor, it is in the record as part of the East Windsor zoning ordinance, which requires developers, in order to get the advantages of smaller lot sizes, etc., to create a homeowners association to govern these associations. And that's where it lies. And let me just say in conclusion, in the words of Chief Justice Weintraub in State v. Shack, we are dealing with, quote, rights too fundamental to be denied on the basis of an interest in real property and too fragile to be left to the unequal bargaining strength